Okay.
Thank you. All right. So the Tenure Support Centre is a pilot that was set up about 4 years ago in CAHF in Cape Town. It's a joint initiative between 71.4 and the Centre for Affordable Housing Finance in Africa. And it was basically set up to do some research into the low-income property market. And arising out of that pilot, we very quickly sort of got some insights into the primary transfer backlog, particularly the various types of primary transfer backlogs that needed to be addressed. And arising out of that, we put together what we call a toolkit, which basically looks at various proposed solutions, various processes that could potentially be followed to try to unblock some of these primary transfer backlogs. So the first thing that we did was we put together 2 toolkits. Casey, would you mind going on to the next slide? The first one is what we call the Land Rights Toolkit, which was basically developed by the guys at GeoAfrica, Peter Hoffman and his team. And that toolkit looks at unblocking the land issues. So issues around your registrations of your townships, your general plans, encroachments, things that are happening on the land that potentially block those transfers from going ahead. What we're going to be dealing more with today is the second part of the toolkit, which is the beneficiary administration and transfer toolkit, which looks at basically once your land is in order and your land is transferable, what is happening on the beneficiary side? So are the correct beneficiaries identified? Are those beneficiaries available? Are those beneficiaries still alive? And can transfer happen to those beneficiaries? So we basically put together section 2, which is the beneficiary administration and transfer toolkit. And there's just a snapshot of the toolkit. I don't know if anybody has had a chance to play around with the toolkit at all. But the toolkit is premised on, there's quite a lot of background guidelines and principles of how the toolkit was put together and why. But then if you look on the very left of the screen, the aim of the toolkit is to try and categorize your particular case into a particular category and then follow the process that flows out of that category. It's a very user-friendly kit. It's quite easy to click and play around on and move between the various sections. And we will share the link to that toolkit. So you're welcome to play around. We would appreciate any comments that come our way. We're also very happy to give one-on-one guidance as to specific areas that problems that you're having in your area, how to use the toolkit for any specific scenario. So that is the background of the toolkit. And what we're going to focus on today, we're going to dive straight into one particular area of blockages with primary transfers, which is deceased estates. So we all know it's inevitable that people will eventually pass away. And of course, with the primary transfer backlog, there is often a significant time lag between a beneficiary being approved and the state being able to pass transfer. So people pass away, that is the reality. And what we're going to look at is we're going to look at some specific examples and specific scenarios of where a deceased estate might be relevant with a primary transfer. I don't know if people want me to go into a deep dive on how a deceased estate is actually reported. Could we maybe have a quick comment in the chat or a quick show of hands if anybody specifically wants me to go through the process in detail, or if that process is quite understood?
I think it's hard to see, but everybody's just sitting quite silently.
Okay, what I'll do is I'll just
maybe do it just a brief summary, and then if people want to ask clarity, they can.
Okay, so you'll see there we've put the link in that circle to the part of the toolkit which basically sets out in a very nice, simple way how a deceased estate needs to be reported. So basically, by law, every deceased estate should really be reported, but we know that that is not always what is happening. And actually, in the primary transfer scenario, as you'll see a little bit later when we go through more of the examples, it's also probably not always, strictly speaking, necessary. It will be necessary when we need to transfer a primary transfer property into a deceased estate, which is one of the processes that can be followed. It's not the recommended process for every deceased estate case, but it is one of the processes. And basically it involves a family member, somebody related to the deceased, compiling quite an extensive pack of forms and lodging those either at the master's office or at a designated service point of the master's office, which is most magistrates' courts. So it's not a particularly complicated process. The forms are a little bit tricky, but they are, with some guidance, they are able to be fairly easily completed. And then those documents basically get lodged at the master's office, and the master needs to issue what's called letters of authority. And those letters of authority is what allows a person, whoever has gone and reported the estate, to act on behalf of that estate. And you will see that it becomes relevant later when we look at transferring to a deceased estate. So you cannot do anything on a deceased estate until you have followed that process. Fill in the forms, report at the master, and get your master's letters issued. Okay, as I say, there's a lot of detail there on that link in our toolkit as to how you actually do that process thoroughly. Okay, I think we can move on to the specific scenarios that we have come across in the work we've done in CAHF. I'm going to be dealing with 3 specific scenarios today. The spouse of a deceased, a co-beneficiary of a deceased who is not a spouse, as well as other heirs of a deceased beneficiary. So these are practical examples that we have come across with our work in CAHF. It's not to say those are the only scenarios, and we would very much welcome other scenarios, that you have come across in your specific areas, so that we can look at whether those could also be dealt with under the toolkit, or whether there's perhaps a slightly different process that needs to be formulated to deal with your specific scenario. So the first scenario, which we come across frequently, is you have an approved beneficiary on HSS. That beneficiary has subsequently passed away before primary transfer could happen. And that deceased was married at the time of their death. Now, the way we have approached this particular scenario is that regardless of whether or not that surviving spouse qualifies for a subsidy or not, the primary transfer should happen to that surviving spouse. And I just want to give you some background or some insight into why we have taken that approach. The thinking behind a lot of the processes in the toolkit is that a beneficiary shouldn't be penalized as a result of what we call life happening. So people pass away, people marry, people get divorced. Life happens while beneficiaries are waiting for the state to pass transfer to them. And it's not really their fault. And so they shouldn't be penalized as a result of the fact that their life has carried on while they were waiting for transfer. So this process is a very simple one. Basically, what you would collect is you would collect the ID of the deceased beneficiary, the marriage certificate showing the valid marriage, as well as that approved beneficiary's death certificate. And on the basis of those documents, you can follow what we call our core process of transfer to that surviving spouse. If you have a look around on the toolkit, there is a whole section dealing with what's called the core transfer process. And you can basically follow that process. It's a standard conveyancing transfer process from state to beneficiary. There's nothing unusual or magic about it. And that is the process that can be followed. I want to just talk you through an example of a particular case that we had. So Mrs. M was an approved subsidy beneficiary for a property in Mfuleni. And actually, by the time she came to us and by the time this all became relevant, she had actually already received transfer of her Mfuleni property. Her husband was Mr. V, and he was an approved subsidy beneficiary for a different property in Khayelitsha. And they had married after their subsidies were approved. So they both qualified each in their own individual right on the basis of single with dependents, but they'd happened to get married before the primary transfer of the Khayelitsha property could happen. So Mr. V then passed away, and basically our process suggests, well, had they been married at the time, or had the state been able to pass transfer timeously, they would have passed transfer to Mr. V before he passed away. And then his wife, as the surviving spouse, would be entitled to that property by virtue of that marriage after his death. So the fact that the primary transfer hasn't happened already shouldn't be a barrier to her rights to that property as surviving spouse. So in this instance, our suggested process is you don't actually even need to report the estate here, because you're doing a direct transfer from the state to the surviving spouse. Okay, so you don't need to even go through that process of reporting. You don't need to wait for master's letters to get issued. You just transfer directly to the surviving spouse on the basis of the documentation that we've outlined there on the left. What will, I just want to sort of put out a warning at this stage, what will potentially trip you up during this process is when you get to the rates clearance stage of your transfer. I'm obviously au fait with how different municipalities work. I can only speak to my experience here in the city of Cape Town. But basically what I'm told is that when you then apply for rates clearance on your primary transfer, you're going to see that that particular person who's getting transfer, in this case, Mrs. M, the surviving spouse, you're going to see that she's actually already had the benefit of a subsidized property, that Mfuleni property. So you are going to have to come up with some sort of an agreed workaround process with your rates clearance department to get that transfer through. So I just want to flag that as this is a good process, follow this process, but you may hit that little bump down the line that you just need to be aware of. Are there any specific questions on the surviving spouse scenario? It's by far the simplest scenario.
Lisa, there aren't any yet in the chat. I don't know if anyone wants to just unmute themselves and ask a question, or we'll just carry on. And then if questions come up, I'll raise them with you. I think you can probably go ahead.
Okay. All right. So that's the surviving spouse. The next scenario that we've encountered quite a lot is you have a co-beneficiary. So you have two approved beneficiaries, but they're not a married couple. So we see this fairly often with, for example, a parent-child who have been approved as co-beneficiaries, rightly or wrongly. That is a completely separate issue for discussion. So not a married couple. So you've got one beneficiary who is still alive, but the other beneficiary is deceased and is not a spouse. So not the situation that we've just talked about. And our proposed solution here is that you transfer to your beneficiary who's still alive, as well as to the estate of the beneficiary who's deceased. So again, the sort of guiding principle behind this suggested process is that it cannot be the state's responsibility, or certainly the state won't have the resources to go and look into who those estate heirs are of that deceased beneficiary, where there's not an obvious spouse or anything like that. It cannot be the state's responsibility to go and weed through this family and find out who the heirs are and who's actually entitled to inherit. So our proposal is, in order to fulfill your obligation to do the primary transfer, just transfer it to the estate. So in this scenario, differently to the one we've just discussed, you would actually need to go and report to the estate, or not you, the family would need to go and report to the estate at the master's office. So if you look at this little box, I've put this little dotted box at the bottom. We've talked about the fact that there's a whole section in the toolkit on how you actually advise beneficiaries or families of beneficiaries to go and do that. Because in this particular process, you would need master's letters of authority. In order to transfer to an estate, you have to have somebody acting on behalf of the estate, and the only person entitled to do that is the person appointed in terms of the master's letters. So the documentation that one would need to collect on this particular type of problem is the ID of the beneficiary who's still alive, the death certificate of the deceased beneficiary, the master's letters of authority, as well as the ID of the person who's been appointed as the master's representative. And this is because that is the person, that master's representative, who's actually going to sign the sale agreement on behalf of the deceased beneficiary, as well as any other documentation that might be needed through that transfer process. I just want to, as an aside at this point, just because we all know the sort of levels of complication that happen with primary transfers, the layers upon layers of things that have happened over the years while the beneficiary is waiting for transfer. You could very easily, in this scenario, have an alive beneficiary and a deceased beneficiary, where the deceased beneficiary actually has a surviving spouse who is still alive. So it immediately becomes a hybrid of this first process we've discussed and the second process. So what you could do is, where you have a surviving spouse of a co-beneficiary who's deceased, you could in this instance transfer to the beneficiary who's still alive and directly to the surviving spouse of the deceased beneficiary. So what I'm trying to illustrate is that these processes that we've tried to set up are fluid. They are able to sort of move between different processes fairly easily. And what we're trying to illustrate is that it's not like, if your case doesn't fit exactly into a specific process, there are options in terms of kind of taking a little bit of this one and a little bit of that one. So once again, we've had quite a lot of interactions with clients who fall into this scenario. So we had a couple, Mr. N and Miss L, who were approved co-beneficiaries for a property in Dunoon in Milnerton. They weren't married, so they were approved on the basis of single but cohabiting. Miss L then passed away, and her estate has already been reported to the master. Her family was very on the ball, and they went and reported the estate. They've had master's letters issued. And so in this scenario, the city can proceed with transfer to Mr. N as the alive beneficiary and to the estate of Miss L as the deceased beneficiary. So what your title deed would actually look like in this scenario, it would actually show Mr. N and estate late Miss L. That's how your title deed's actually going to look. I just want to point out that writing in the red there, this process will fulfill the state's obligation on the primary transfer. So the state can sort of tick that one off its list. My primary transfer has happened, I've transferred it to somebody. It unfortunately doesn't help your heirs of Miss L's estate, because the property is then registered in her estate. They would then still, independently of this primary transfer process, they would still need to go and get some legal assistance in transferring that share of the property out of the estate into their own names. So the work of the TSC, I mean, that is something that we do. We look at obviously transferring to the end person, the person who actually needs to end up with the property. I just wanted to illustrate that obviously that is not within the realm of the state's concern. Your concern is the primary transfer into that estate. Okay, any specific questions on that at this point, or we can move on to the next one?
There aren't any questions in the chat. I mean, this one I think is so interesting, Lisa, because what you've got is you resolve the administrative barrier, the administrative problem of the fact that there hasn't been a primary transfer. But you do have to then deal with the fact that there are people who have inherited that from estate late Mrs. L, and they need to find way to engage. And that could also create a relationship with Mr. N and so on. And so that management of that relationship, that's something you say the TSC does.
Correct. Yes. So we would then, and we've done this, we have actually done this practically, is we've then received a title deed from the city, registered in the name of estate late. So the city ticks it off. We've done our primary transfer. We are happy. And basically we then take the title deed and we do a deep dive into the heirs. We see what's been reported at the master as to who the heirs are, and we then do the on transfers from the estate into the names of the heirs. Yeah. So that is, I mean, although it's not a particularly onerous process necessarily, although I say that bearing in mind one has to deal with the master's office, which is unfortunately not the most efficient of departments to be dealing with. It is perfectly possible. But obviously for your normal man in the street who doesn't have access to the TSC necessarily, it is going to have a cost component because they're going to have to pay a conveyancer to actually do those estate transfers, which we know for people in this market is not necessarily affordable.
It strikes me then that it would be useful. I mean, this toolkit would be useful also to the other legal NGOs that are operating, and we should be disseminating it as well to them. So like pro bono and other the CALs and so on, because in a jurisdiction where the TSC is not operating, they should be able to get additional legal support around these kinds of issues. Yeah.
Agree. Yeah, definitely.
That's
just
great.
Before we move on to the next slide, I just want to, I always like to try and illustrate the sort of layers of complexity that can arise with a primary transfer backlog case. So the case details that I've outlined here on this particular case, I've had a little bit of, I've amended it a little bit to fit the specific scenario. I just want to show you what actually happened in this case. So we had those two approved beneficiaries on the basis of single but cohabiting, and in actual fact, both of them have deceased. Both of them are deceased. So and it's an existing client of the TSC. We act for the family of Miss L, who came to see us and said, this is the scenario, here are our master's letters, what can we do? The problem is the family of Mr. N. They are not willing to go and report the estate. They are not willing to get anybody appointed as master's representative. They have essentially taken over the property to the exclusion of Miss L's family, which they are renting out and receiving rental income. And so now we find ourselves in the situation of basically a dispute. There are two parties involved, two beneficiaries essentially involved, who cannot agree on how to move forward to primary transfer. We have put it to Mr. N's family that they are both entitled to the property as co-beneficiaries, and that please will they cooperate in getting master's letters issued so that the transfer can proceed to these two estates. And so that then after the primary transfer has happened, at least you've secured your rights from the state, and then we can figure out what to do. And the answer has been an emphatic no. So this becomes what we call a dispute case. And I want to point out that in the toolkit, there is a whole section on dispute cases. So once again, you could find yourself following this process number 2, it all seems to be going very nicely, and then you get to a dispute. There is a mechanism in the toolkit where we discuss in detail how we suggest you approach a dispute, with a lot of detail on how that should run or how that could potentially run. So just to show you that there, you don't necessarily follow one path and stick with that path from A to transfer. It sometimes does more of that along the way. Okay.
That's brilliant, Lisa. Thank you.
So the third scenario is where there is one beneficiary who is deceased and there are heirs, but those heirs are not the spouse. So it's usually children of the deceased. It can be siblings of the deceased, brothers and sisters. I've just put a little star there to a link to a website through the Master's Office of a detailed explanation of how the laws of intestate succession work. It's not strictly speaking relevant, I don't think, in the space that many of you will be working on, but it is a nice read because it is nice to understand that the laws of intestate succession are very specific. They are unfortunately not always completely in accordance with other, for example, African customary rules of succession. So it's very important to advise somebody who might come and see you about this kind of case that what a family thinks should happen in terms of who should end up with the property is unfortunately not what the law says should happen. It's a very important message to get across. You know, we often have clients who come in and say, yes, but my mother had said that I could have the property when she passed away. When in actual fact, there are 5 brothers and sisters, and the law says that unfortunately, if you didn't leave a will saying that I only want my one son to get the property, then by law, everybody gets the property. So it's just, that's an important thing to bear in mind always when dealing with deceased estates, but there is a link there if anybody is interested in a bit of background reading on that. So the process that would need to be followed here, and sorry, just as some background again as to why we put the process together this way, is that the thinking is again, had the state been able to transfer timeously to this beneficiary, the beneficiary would have had a title deed in his name. And when he then passed away, well, then of course his children are the intestate heirs, and they would have been able to secure title to themselves by virtue of the fact that he owned a property. It was his property, it was in his name, and they are the heirs. The fact that that primary transfer didn't happen shouldn't penalize those heirs. So those heirs should be allowed to secure the same rights that they would have had there not been a backlog with the primary transfer. So the process is very similar to the one we've just discussed. You would basically collect your death certificate of your deceased beneficiary, your master's letters of authority. So again, you would have had to advise that family to go and report to the estate, wait for master's letters to be issued so that they can bring you the master's letters of authority, as well as, once again, the ID of the person who's been appointed in terms of those master's letters, because again, that is the person who would actually sign the sale agreement with the city or the province or whoever. And then once you're happy with all of that information and it all stacks up, you would basically then again be able to proceed with your transfer to the estate late. And again, it's exactly the same process as your normal core transfer process. Oh, can you go back one slide, Kezia? Thanks. It's exactly the same. It's just that your title deed will show estate late Mr. X instead of his name. Okay, so this particular case that we had, Mr. N was an approved subsidy beneficiary for a property in Guguletu. He passed away, he didn't leave a will, and he had 3 children who, according to the law, would be his valid heirs, the people entitled to inherit. His family, once again, had done their homework and gone and reported the estate, the master's office, and had received master's letters of authority. And so you would, in this scenario, be absolutely entitled and able to proceed with transfer to his estate. And then again, I've just made the same point as I made on the previous slide. It ticks off your checklist of your obligation to transfer, the primary transfer. It unfortunately doesn't help the heirs, and they would then need to go and get some independent assistance in securing transfer into their name.
Lisa, there's a question from Plantla who's asking, how do we deal with deceased beneficiaries where the death was not reported?
It's an excellent question, and we do have a client like that on our books. So the reporting of the death, I presume you mean on the reporting at Home Affairs. I'm assuming that's what you're talking about. So there are a couple of documents that get issued when somebody passes away. And I understand that this may be different in rural areas It's not my area of expertise, but so basically when somebody passes away, there should be what's called a death notice, which your person who signs them off as deceased, it's usually a doctor or, you know, somebody at the morgue, will sign that death, I think it's called a death notice or death form, to basically confirm that that person has passed away. And then usually at the same time, a burial order will be issued to say that this person is in fact deceased and you can proceed to bury them. So those two documents, as long as the person has those two documents, they can then always still go and report that person as deceased at Home Affairs. And obviously, the only way you're ever going to get a death certificate is by reporting the death at Home Affairs. To answer your question, if you don't have those two documents, I actually have no idea, and it's something that we can certainly look into. You know, if it is of relevance to your specific, if you're seeing a lot of these cases and you need some guidance on what to actually do. But at the end of the day, I mean, you're going to have to get some sort of proof that somebody is deceased, so that you know that they haven't just disappeared, or the family is saying they're deceased when in actual fact they're not. So just indicate in the chat if you'd like us to do a little bit more of a deep dive into how you could get around that. Okay. All right, I think we can move on. Those are the processes that we've outlined based on what we have uncovered with our work in CAHF. Those are the sort of obvious deceased estate scenarios that we've encountered. We're well aware that there may be others, and as I said earlier, we would very much welcome those so that we can look at possible other processes that you might need. I want to end off with a few sort of warnings or a few discussion on a few things that can go wrong during this process. The first being the customary or common law spouse. The second being minor heirs, I think it is. And the third being, yes, where your master's letters omit the property in question. So, and these discussions are sort of more as a, just have a think about this while you're going through the process so that you can advise beneficiaries properly, so that you can maybe preempt some of the problems that might arise down the line. So the first case is the customary or common law spouse. So we've had quite a few of these. This particular client, Mr. B, came to see us because with regards to primary transfer of a subsidy property in Gugulethu. So he tells us that he was given the property by it would have been, I think, the provincial province Western Cape, or it could even have been the city of Cape Town, as it would have been then, probably city of Tygerberg, with his then cohabiting partner. So they weren't married. She is now deceased, and actually they weren't approved as single but cohabiting. She was approved independently of him on the basis of single with dependents, which happened to be their own biological children. Why it was approved that way as opposed to on the basis of cohabiting, I'm not sure, and neither is he. But basically, he's not an approved beneficiary at all on HSS. The fact is he was her common law husband, and they lived in that property for almost 20 years before her death. He still lives in that property, and he's now coming to us and saying, well, what can I do? So as we've seen in the process we've just outlined, the third process, we have a process for how to transfer a property to a state late beneficiary. So the deceased in this scenario, remember, she wasn't married, so there's no surviving spouse. There was no approved co-beneficiary, Mr. B. So the third scenario is, well, there must be other heirs, and there are. The heirs are her children, who are in fact also his children. So in an ordinary scenario, we would say, fine, go ahead and transfer to estate late deceased, and then let her children secure the transfer to themselves as heirs. So you can just bring up the next block for me, Kezia. So, but basically what the sort of warning we want to put here is that he's lived in the property for 20 years. And in circumstances like this, it might be prudent to sort of exercise some discretion in looking at the claims of the occupant versus the claims of an heir who has got his own life, he's living elsewhere, but now has popped his head up and said, oh no, but hang on, it's my mother's property. And because she wasn't married to my father, I'm actually going to jump ahead of him in the queue and try and secure this property for myself. So, yeah, I mean, there are various options one could look at here. You know, one could look at saying, I know in the city of Cape Town, there's very much a premise of trying to regularize occupation. So you want to try and keep the people who are in the properties, rather than ejecting a man who's lived here for 20 years merely so that you can follow a proposed process. So there are various options. You could look at possibly securing a subsidy for Mr. B directly. You know, whether he would qualify now, 20 years down the line, is another story. Probably he would qualify on income. He probably wouldn't qualify anymore on, I mean, he's not going to have any dependents anymore. His children have all grown up and moved away. So it's not clear cut. It's not a, you know, an easy one to fix, but I just bring it up just so that, you know, to make you aware that sometimes one does need to think a little bit outside the box. And exactly the same would be true for a customary marriage where that customary marriage hasn't been registered. So we have a lot of those. The clients have never registered their customary marriage. They don't have a marriage certificate from Home Affairs. So they can't prove the customary marriage. And with a customary marriage, it's very difficult to prove that you are in fact the intestate heir. So had he been married to her customarily, as opposed to just living with her as a partner, he would be in exactly the same scenario. He would not be a valid intestate heir unless he goes through quite a process to try and prove that customary marriage. And he's also not approved as a co-beneficiary. So he finds himself in exactly the same scenario. Okay, the second possible thing that can go wrong is where your intestate heirs, so your people who are left behind after your beneficiary is deceased, are minors. And we see this all the time. You have a single person who's approved on the basis of single with dependents, and unfortunately passes away and leaves behind only minor children. So this particular case, Ms. K, she's an approved subsidy beneficiary for property in Khayelitsha. She passed away and left behind only one child aged 13 years. So what we've done is we've tried to report to the estate for her, and we've been trying for 18 months to get master's letters issued. And the reason why this is not going really according to plan is that the master won't issue letters of authority where the heir is a minor unless an attorney is appointed as master's representative. So this is a process that we've had to learn by trial and error. I'm not an estate lawyer by background, but so a lot of the things that we try through the master's office are really just, well, let's try it and see what happens. The master didn't like the way we reported it, and they've actually now insisted that myself as an attorney be appointed as the master's representative, which is fine. We, you know, if the family has access to something like the TSC, it's all good and well, because obviously we're not going to charge them for that, for holding their hand through that process. But where they don't have access to something like the TSC, they would have to go to an attorney, and that attorney is then going to charge them a considerable fee to actually manage the estate for them. So that is potentially very problematic. The second complication is that even if you can get master's letters issued and you can transfer the property into estate late deceased, in order to ever get that property out of estate late and into the name of the heirs, whether that's, you know, one minor child or several minor children, if the other biological parent of those children is no longer alive or cannot be located, you will need to actually have a guardian appointed. You can bring up the next box for me there, Casey, please. So by law, your two biological parents are your natural guardians. They can assist you as a minor in signing documents, in contracting, in whatever a normal major would be able to do, a minor needs the assistance of their guardian. So obviously in this scenario, Ms. K is the biological mother. She's already deceased. One would need to then try and find the biological father of the minor child, so that he would be then the one able to sign the sale agreement or sign transfer documents on behalf of the minor to secure transfer of that property into the minor's name. So if that biological father cannot be found, or is not willing to cooperate, or doesn't even know that he has a child, you would need to actually bring a guardianship application. It's a high court application, so it's not a cheap process. And again, I mean, if the TSC was not accessible to the client or something like the TSC, again, they would have to go to an attorney. They would have to pay the costs of a guardianship application, which is not an insignificant cost. So similarly to the scenario we've just discussed with the customary or common law spouse, again, sometimes it might be prudent to think about whether a primary transfer to the estate late, where the only heirs are minors, is actually going to be of any benefit at all. You might find that you follow this process and you transfer to estate late, and actually that minor child never has any hope at all of being able to secure transfer, because they can't afford a guardianship application, they can't afford to a lawyer to act as master's representative, etc., etc. So, again, in this scenario, I mean, there are various things one could look at. I suppose the obvious thing to ask would be, well, who is looking after the child? Is it a relative, is it somebody else living on the property with the child? And perhaps it might be better to look at securing transfer to that de facto guardian instead. So would that person qualify for a subsidy? Could you regularize transfer to them directly? And then, maybe you would advise them on, well, actually, maybe you want to do a will so that that property definitely goes to that minor at the end of the day, etc., etc. Okay. And then the last scenario, the last problematic area that we've encountered is that in the primary transfer space, when you report an estate at the master, you have to complete, or the family has to complete, a document called an inventory, which basically lists all the assets of the deceased. So anything from cars to houses to money in the bank, everything that deceased owned at the time of their passing. The master then looks at that inventory, and when they issue master's letters, they reference all of the assets on that inventory. And the reason they do that is because whoever is then going to be responsible for moving those assets out of the estate into the names of heirs needs to be authorized to do that in terms of the master's letters. So when you see a master's letters, you'll see it has a little block at the bottom saying Earth 12345 Kailicha, value 72,000 Rand. And that document is what the conveyancer then uses to transfer that property from that property 12345 Kailicha from the estate to the heir. Without a master's letter which specifically references the property that you're trying to transfer, you will never ever be able to do that transfer. I'm talking now about the transfer from estate late onto the heirs. Now, the problem with a primary transfer property is, of course, the primary transfer is not yet in the name of the deceased. I mean, this is where we're stuck, and this is what we're trying to actually secure, is transfer into the name of the estate. But if you don't include that property in inventory, it's going to be omitted from the master's letters, and then it's going to be stuck in the estate forever. So our proposed solution, if you can just bring up the next block for me, Kezia, is that when you tell an heir to go and report to the estate, you must tell them to include the primary transfer property in the inventory. So you give them the earth number. This is the earth number your deceased beneficiary was supposed to get. Please, when you fill in the inventory, include that property. Now, the master's then going to ask you, where is the proof that this beneficiary is in actual fact the approved beneficiary for this property? Because the master needs to know either there's a title deed for that property showing that you own it, or you have some other rights to that property. So what we suggest you do is that you print an extract from HSS for them showing Mr. N was approved a subsidy for property 12345 Khayelitsha, and its value is 84,000 Rand, which is essentially the subsidy value. And give the beneficiary or the family that document or that printout to take with them. They will need to annex it to the inventory to show the master, okay, my deceased is entitled to this property, it's valued, and the value is relevant because the master must determine what kind of an estate it is. We can touch on that a little bit more when I finish this section. But so they need to show that the beneficiary was entitled to that subsidy as well as what the value is. And then the master will be able to issue master's letters showing deceased estate Mr. X, property 12345 Khayelitsha, valued at 84,000, which means that once the estate has fulfilled its obligation to transfer to estate late, the heirs can then take that master's letters and actually secure transfer out of the estate into their names. Okay, so that's something to be aware of and to advise potential beneficiaries or families on. All right, that sums up what I wanted to talk about. Are there any specific questions on deceased estates in general, or any specific scenarios that you've encountered in your areas that maybe don't fit into what we've discussed today that you'd like some guidance on?
If colleagues would just like to unmute yourself and ask questions directly, we've got a little bit of time.
Morning.
Morning. Good morning.
Yeah, my name is Takalani from City of Tshwane Human Settlements Department. I just want to check, because I'm seeing that the presentation is more focused on proclaimed or formalized areas of the cities, and which excludes most of the rural areas of South Africa. How do you address the issues of the rural areas, I mean the tribal areas, in this kind of an instance? But I also want to wind it up to here in the city of Tshwane. We've got agricultural holdings where owners of big stands, they allow people to stay into their plots, and people build their houses with the full knowledge that the owner is still the custodian of the land. The land still belongs to Mrs. X or Mr. X. But when there's a death in the family or one of the subletting people, they end up coming to us as the municipality to say, you must give us a letter of authority to go to the masters. And in all fairness, there is no linkage between the municipality and the landowners. But we see that occurring now and then, and also it also affects a lot of foreign nationals who come to us as well and talk to us about these things. I just want to hear your view on that.
Okay, can I deal with the second one first?
Okay.
The issue of, I mean, let's call them backyard inhabitants, because that's really what they're doing. The way I'm understanding you, they're setting up their own little structure on somebody else's earth. Has that earth already been registered? So it's not a primary transfer anymore?
The land is owned in terms of a title deed by this individual.
Okay.
Yeah.
Okay. So you're quite correct. I mean, once your primary transfer has happened, the obligation from the city has essentially ended in respect of ownership. So all you could really do, I think, in that scenario, so the backyard inhabitant, actually, unfortunately, as we all know, has no legal rights to ownership to that property. The very best they could hope to secure for themselves is some kind of a lease with the owner. And we have encountered this scenario quite often in Cape Town, where we've been asked to advise on exactly that, securing a lease for a backyard dweller, which envisages the death of that backyard dweller and make some sort of provisions as to what will happen after the death of that backyard dweller. So will the family be allowed to stay on? What happens in the event of the death of the registered property owner? Because that is another scenario that needs to be dealt with. You know, if your registered property owner passes on and the family want to sell the property, or the family want to move on to the property and they don't want people living in their backyard. So the backyard dweller, I mean, their rights are very tenuous, and all you could really advise them is to at least get some sort of a lease agreement drawn up, providing for all of these scenarios. I mean, at the end of the day, a title deed will always trump a lease, you know, in terms of who has the more secure rights. But you can at least try and send them to somewhere like Pro Bono or the Legal Aid Board or somewhere like that to at least assist them, or even us, to assist them, you know, with at least trying to secure some of their rights. Does that answer your question?
Thanks for that clarity. Thank you.
Just on the rural, your question about the rural land, the tribal land. You know, it's not an area that we have had much exposure to. It's not something we see a lot in our work here in Khayelitsha. So my answer to that would be, I don't actually know, and we can certainly look into that in more detail for you if that is something that you would like specific guidance on. I mean, at the end of the day, with tribal land, you know, the way I understand it is some areas of tribal land have actually quite sophisticated systems of ownership, you know, with PTOs that are issued and actually quite good records that are kept in terms of who is allowed to occupy the land, why, etc., who is deemed the owner of the land, etc. I'm certainly happy if you have specific issues around that you'd like some guidance on. We can certainly have a look at that for you.
I think just a quick one, because here within the city of Tshwane, we've got tribal land, which we do have, you know, tribal authorities which are ruling over those lands, but they're within the city. So a lot of activities happens whereby you find out that this is beyond the municipality can handle, and so you try to think, how do you, because you cannot register a title deed on the land which is tribal, because already there's a title deed which is covering the whole land. What will be the best option for the families to register their land within a tribal land, you know, things like that?
Okay, so that's a good question. The one option that we've looked at in quite a lot of detail is the option of registering leases over that land. So what you do is let's say you've got a huge piece of land with, I don't know, 50 families living on it. It is possible to designate lease areas on that property. It does require quite a lot of work because you actually need to survey those areas and register them as separate leasehold areas. And then you can actually give somebody, it looks like a title deed, it's a certificate of registered leasehold. And it basically says you have the rights to live on this property. It's usually capped at about 99 years as a long-term lease, but it can be for a shorter period. And it's as good as a title deed, but it's as good as a title deed is going to get when you can't actually have a title deed, if I'm explaining that properly. So it records your rights against the property register. Those leases are actually registered against the title deed. And there are various restrictions on the parts of both parties, the registered landowner as well as the leasehold owner, as to who can do what with that land. So it is quite a nice way of securing title, was good as title, but it does have some cost implications from the survey. It's quite manpower heavy in terms of doing the leases, monitoring the leases, etc., etc. But it's certainly it's quite an elegant solution.
So will this, sorry, just for making a lot of follow-ups, because I think it is hitting home a lot with what we have just presented and the information that you have given us. So ideally, I'm thinking, will the issue of registering a trust to protect land for these families assist them in the future?
By a trust, you mean sort of like one big trust where each family is represented? Is that what you mean?
Yeah.
You know, I know there's been a lot of debate around the sort of concept of common ownership. I personally don't like it because I think it requires so much cooperation from so many potentially conflicting parties that I think you can end up with a scenario where it doesn't actually achieve what you're trying to get it to achieve. I mean, you can, for example, have some kind of a governing body where representatives from each family come and are entitled to make decisions together and stuff like that. The problem is going to be where you don't agree, where you can't, you know, all unanimously want to do one thing or the other thing. So it can get very messy, and it's also quite, a trust itself is quite an onerous instrument to manage. So it's got to be registered at the master's office, and every time somebody passes away and the family wants a new trustee to be appointed on behalf of that family, it's got to go through the master's office again. It's quite an administratively onerous instrument to manage. But it is certainly possible. I'm not, you know, suggesting it's not a solution. I do think that there are other solutions, like, for example, a leasehold, or even if you don't register the leases, even if you just do more formal lease agreements rather than just a PTO or something like that, even if it's not registered, at least it secures rights a little bit further. So, yeah, I mean, I certainly think there's a lot to be unpacked on this particular discussion point, and perhaps, you know, perhaps if there's a need for it in Tshwane particularly, or even in other areas, perhaps we could do a separate learning session on this issue. I see we've got quite a lot of hands up. Haley, do you, I think, yeah, Haley, do you want to go ahead?
Seppo was first. Seppo was first, and then Haley. Are you happy to carry on? We've got over time, but I think if you're happy to carry on, we can go a little bit. Seppo, go ahead.
Yes, good morning, colleagues, and thank you for affording me this platform. I'm with the South African Housing Club, and what we do is to facilitate home ownership programs for different mining companies. So we normally have this issue that I think maybe this is the right platform to address it, whereby the employees would have been allocated stands by the council. These employees would have gotten this stands for more than 5 years, but the council would have a problem in terms of giving them title deeds. The stands would have municipal services like electricity and water, but then it becomes a problem in terms of the members benefiting from those housing schemes, because now, as you know, there must be a security for the mine on those houses. So without proper proof of title, they are unable to benefit from these schemes. I'm not sure if there is some alternative proof, alternative proof of ownership or rights to property that we can assist those specific people with.
Thank you, Seppo. Yeah, I've actually had quite a few conversations with Riata, who I think is your colleague, on exactly this issue, on how we show the mining companies that these particular beneficiaries are actually entitled to those pieces of land. And I think there's quite a bit of work that I need, or between Riata and I, we need to look into as to what exactly the impediments are. I think it's predominantly the Northern Cape, is that right?
That's for sure, yeah.
Yeah, I think there's a little bit of background work that needs to be done in terms of what exactly the impediments are to transfer in this particular area. You know, because if if it's from a beneficiary administration perspective, there's a lot of work we can do to help them with that. If it's land legal, so in other words, if they're having problems with registering these particular urban that need to then be given to beneficiaries, that's also something that the first part of our toolkit could probably properly assist with. So I think the first step is to first try and understand what the impediments are, because to build a solution designed to solve a particular impediment is, I think, far more effective than just a sort of a general solution. But just to answer you very generally, I mean, apart from a title deed or a PTO or a registered lease over an area, there isn't in law really any other proof of ownership. So, I mean, I think leasehold again could be an option that could be looked at if there is a designated piece of land, but there's a problem within that land in terms of, for some reason, subdividing and registering title. But I think there's some work that we need to do between, myself and you and Riata, that we can do a bit more of a deep dive, and then we can better advise.
All right. So if I'm understanding you correctly, what we need to do is to try and understand exactly what the issues are, and then we can come up with relevant solutions. So meaning maybe consult the local municipality and ask around if what the problem actually is that's delaying the registrations.
That's exactly what we need. So, I mean, we are very happy also to have those discussions directly, but we would need, we would need contact people. We'd need to know, I know there's 2 particular municipalities that are involved, but we would need to know, who do we talk to? Because, obviously we have the insight into, they're going to tell us A, and then what does that mean? So, we can chat. You can possibly get us some contact people, and we can have a little bit of a deeper look into that.
Okay. All right. Thank you so much, Lisa.
Okay.
Lisa, we've got 2 more people who want to ask, and I'm going to say maybe if we carry on until 11:15. Is that fine with you?
Fine with me.
Okay, Hayley, go ahead.
Thank you. I'm going to use a case of the city of Cape Town, where approximately 20 to 25 years ago, the city deeded their council houses to the renters, and so they became owners. And they discounted the deeding process to, like, I think 1,500 at the time. So now I wanted to know, because this process of estate late and, the whole administrative process seemed to be very burdensome and also costly for people who are living below the poverty, or just about on the poverty line. And there's no escape from the processes that are involved in transferring title or transferring estates, especially if somebody has passed on, and the short time frame that one has to actually ensure that you don't default on the processes and the time frames. And oftentimes one is left to attorneys to assist, and I mean, they do a great job and everything, but they're also very expensive. So it can cost upwards from 15 to 20,000 to actually, like if you're married in community of property and your spouse passes on, then you have to transfer title to the surviving spouse. So, and then that also ends up being costly for the surviving spouse, especially if you're indigent and you're a pensioner and all of the above. So my question is, being a representative of the Department of Human Settlements and in the policy unit, is there something that we can do? Should it be with the Department of Human Settlement? Should it be with the Master of the Courts Department of Justice and Constitutional Development? Should we not be putting something in place that can assist the poor, that can assist even our beneficiaries of subsidized houses, to be able to access this process without it being burdensome to them? Because I find that there's no escape. As I said earlier, there's no escape from having to go through this costly process, even during a time that one has to deal with, grief and and all of the other challenges. I mean, also the knock-on effect of even an income person that has been perhaps even a breadwinner that has now passed on. And now the surviving family is left with no income, and then, or they've been affected, you know, by the loss of the person, and now they haven't planned, because we don't plan if we're poor. We don't plan for the what-if scenarios. So should we as government, as human settlements, as constitution, justice and constitutional development, these departments, should we not be partnering to be able to reduce the burden on the poor in order to, so that they, look, we're also trying to create through our housing programs, we're also trying to help people put a roof over their heads, and also to build wealth in a small way. But now we're also causing them to, by giving them title to our housing, the houses that we build by government, we're also causing them, in a way, a burden to be able to do this process. So I'm wondering if you have any thoughts on that. Thank you.
That's a great question, Hayley. Thank you. So the work that the TSC does, so sorry, excuse me, I've pretty much outlined for you the operational side of it. So clients coming in our door, this is my problem, please can you help me? And then we register a title deed for them at the end of the day. There's a lot of work that the TSC also does, exactly as you've just described. So basically taking the learnings that we have uncovered, things like people cannot access formal conveyancing processes, people cannot afford to wind up deceased estates, things like that. And we take those and we try and drive changes in the policy space. So it would be very interesting, I think, to have a further discussion with you, perhaps at another stage. About, so, for example, one of the things that we've tried to do is we've tried to say, we've motivated to the deeds office to say, well, if your property is worth less than 200,000 Rand, you cannot afford to pay these kinds of deeds office fees. So there should be a kind of like a blanket rebate on deeds office fees for properties worth less than a certain amount. Similarly with rates clearances. Your rates clearances for properties below a certain amount should be free. All of these kind of things to try and strip out the cost. Because you're right, I mean, at the end of the day, your only option at the moment to secure a proper title is to go through these formal processes, which are inaccessible and expensive. So we do try to do quite a lot of work in that space. For example, with deceased estates, there are two processes at the moment. There's what's called the small estates and the large estates. And if your estate, let's just call it your property, because that's usually the only asset in the estate. If your property is worth less than 250,000, there's a very much cheaper and quicker and more efficient process you can follow in the master's office, as opposed to if your property is worth more than 250, which is a very expensive and cumbersome and long process. And to your point, you know, these are people who are grieving, and these are people who've often lost their breadwinner, and now to put them through a 2-year winding up of deceased estates process is ridiculous. So one of the motivations that we tried to make to the Department of Justice was to say that 250,000 Rand is too low. You know, we've seen what RDP houses sell for in the resale market. You need to make that value higher so that more people will fall into this cheaper, quicker, easier process. So yes, I think, Hayley, we would definitely welcome a discussion around more of the sort of policy space and work that could be done there. Just on your specific clients that you're talking about, so this is exactly the work that the TSC does, and you are more than welcome to refer them to us. Basically, our model works that for clients who are pensioners or clients who are on disability grants, they don't pay anything for transfer. So basically the whole process will be done for them for free. With clients who are not disabled or pensioners, we've capped it at a very, very small amount. It's about 1,300 Rand that they have to pay for transfer, which is going to be by far the cheapest, most accessible way of them securing a title deed. You know, we've stripped out all those costs. That's all they have to pay. and I mean, these pictures that are here, these are all clients who've paid their 1,300 Rand and they've secured a title deed at the end of the day. So please, we would very much welcome, you know, whatever you want to send our way. Nonhlanhla.
Thanks very much for the presentation, Lisa. For me, I just wanted to comment on the issue of the master's office. I think it's very critical that the master's office needs to go out.
I think you're on mute, Nonhlanhla.
Nonhlanhla, you're on mute. Suddenly your microphone went on mute. We can't hear you.
Hello?
Yes, maybe you should start again.
Okay. Can you hear me now?
Yes.
What I was saying is that the master's office needs to go out to the people. Not, you know, it's so people, they take the last money they have, they go to the master's office only to be returned that you need this document, that document, that document, and then there are family disputes. We need to educate people that if a person has died interstate, then that property will then vest with the deceased. All the equal members of the family will have the equal share, because we have seen quite a lot of disputes where they don't want to get letters of authority issued to an individual because the individual will take ownership. But it's very critical that they understand that all the members of the family have the equal rights. The other issue that I wanted to comment on is the issue of the farm dwellers and the mine towns. There is a team from the National Department of Human Settlements that works specifically with regard to providing support to the farm dwellers. I think and also the mine towns. It's very complicated, but I think the National Department is working on something that will try to ensure that people do get a form of security of tenure. And on the issue of legal aid, I think their mandate should be amended, because there is an interministerial committee that deals with the crisis. This matter needs to be escalated to that committee to say the legal aid their mandate should be extended to deal with the issue of assisting the indigenous people, because there are quite a few, there's quite a lot, not a few, of people that fall within this category. In the Western Cape, at least, you do have the initiative through your support. But in other provinces, there is no support for this initiative of people having to pay the 1,300, which is a flat rate for getting assistance, and the pensioners not having to pay. But I think there is a lot that can be done, and there are government institutions, it's just that they are not properly coordinated to provide this sort of support. Thank you.
Thank you, Nonhlanhla. I'd be very interested to talk to you further about the work that's being done in human settlements about the mining houses. That sounds like something we would definitely like to look at further. And you're quite correct. I mean, it's a question of finding the right conduits for people to access. I think that's, I mean, you're right that they do exist. How efficiently they work is another story. You know, we've done quite a lot of work with a specific pro bono organization here in Cape Town, which unfortunately has just not really achieved any significant results. The Master's Office, yes, the Master's Office should go out to the people. We believe the Master's Office should be electronic. You know, you should be able to submit everything electronically, get your master's letters issued electronically. There's a lot of work that can be done in that space to make that process more streamlined, because at the moment, I mean, we can wait months and months and months and months for the master's office. Okay, are there any more questions before we finish up?
I think that we've covered them all, Lisa.
Yeah.
Have we set the date for the next learning series?
We haven't. We haven't, nor have we set the topic. So I think if yourselves or your colleagues, if there's anything that you would really like a deep dive into, a specific issue that you're having in your area, if you play around on the toolkit a little bit and stumble across something which you think, oh, that could really help us, can we have a more detailed discussion on that? We would really welcome that, so that we can try and tailor these sessions, you know, to your specific requirements rather than a general discussion.
That's great, Lisa. Thank you. So what we'll do is we're going to take this recording and we'll publish that onto the website so that it can also be shared. And I mean, what's astonishing in your presentation, and we work together all the time, but is really the variety and the nuance from one case to the next. And I think where you've really provided hope is that each one of those very particular cases can actually be addressed, that there are mechanisms to do that, and developing following those steps as it's recorded in the toolkit and then amending it into particular circumstances. That's all possible. So I'm hoping that this learning series will really be useful for people as they explore the different cases that they come across in their own local contexts. We have your details from your registration, so we can contact you and we'll let you know when the video is available and when there's the next learning session. And please also forward the invitation to your colleagues. We're very happy to invite anyone who wants to